Let's start directly with the disturbing teenagers who got convicted in court. A woman who was a teenager when a video of her sentencing went viral in 2017 as she broke down in tears while her mother wailed, was back in court trying to get her conviction and sentence vacated. Andrea Cook, 24, did not succeed. A judge rejected a motion by her attorney, Anthony Candela, who argued, among other things, that her previous attorneys had failed to present mitigation in her case. Cook was the face on a Meet Me app profile as part of a ruse to lure Perry Nita of Palm Coast to a meeting to rob him. Nita brought along his friend Emmanuel Manny Purcell of Palm Coast to the meeting in South Daytona. Cook's accomplice and boyfriend at the time, Kendrick Bass, ended up shooting and seriously injuring Purcell during the attempted carjacking. Take a second now to subscribe and like the video to help the channel creating more content for you. Cook and Bass teamed up for another carjacking just 2 days later, police said. Cook, who was a mainland high school student at the time, expected probation at her sentencing because that's what her defense attorney had told her would be the punishment. Instead, Judge Matt Foxman sentenced her to 20 years in prison. That sparked the viral video of Cook and her mother's reaction in the courtroom. After the sentencing, 2 new attorneys took over her case, Stephen Robinson and Kelvin Daniels, on a pro bono basis. Cook was allowed then to withdraw that plea because she had expected probation based on what the attorney had told her. There was no crying when Cook took the stand. She testified that no one told her she could go to trial instead of taking the 11 years in prison. But she did admit agreeing to take the 11 years in prison. Circuit Judge Karen Foxman ruled that she found Cook's claim credible, that she was not told she could go to trial. Foxman also ruled that she found that Robinson and Daniels made strategic decisions due to the evidence against their client, including her violating a judge's order. Karen Foxman is the wife of Matt Foxman and took over his docket when judges were reassigned in 2021. Bass, 22, was later sentenced to 20 years, according to the Department of Corrections. Cook is scheduled to be released in January 2028. Next case shows 19-year-old woman given 2 concurrent life sentences for fatal 2022 crash that killed 2 people. Mackenzie Sharilla, the 19-year-old woman who was found guilty of murder for purposely causing a car crash that killed her boyfriend and his friend in July 2022, was sentenced to 2 life sentences for the murders, to be served concurrently. Sharilla will serve a minimum of 15 years in prison for the 2 concurrent life sentences handed down by Judge Nancy Margaret Russo Monday afternoon. The families of 20-year-old Dominic Russo and 19-year-old Davion Flanagan are still left in pieces. Mackenzie showed no mercy on Dominic, nor did she Davion. Sharilla had been charged with 4 counts of murder, 4 counts of felonious assault, aggravated vehicular homicide, drug possession, and possessing criminal tools, according to court records. Last week, she was found guilty of all counts in a Cuyahoga County Court of Common Pleas. Even if Mackenzie also intended to die in this crash, that is irrelevant, said Russo. A failed suicide attempt is not a defense to murder. During the sentencing, the prosecution argued Sharilla has no remorse and showed videos of her going to concerts and college parties after the wreck. Sharilla's mother said she encouraged her to go to those events. The crash happened just after 6 a.m. near Progress and Alameda Drives. The occupants, Sharilla Flanagan, 19, and Dominic Russo, 20, had to be extricated from the vehicle. Sharilla was flown to Metro Health in Cleveland for treatment, while Flanagan and Russo were pronounced dead at the scene. Court records show that Sharilla did purposely cause the death of the 2 teens by crashing the vehicle she was driving. This case showed a brutal act of a young girl. Take a second now to subscribe and like the video to help the channel creating more content for you. Next case shows a young girl reaching a $5 million settlement in daughter's death case. A Missouri woman whose 9-year-old daughter was killed by a teenage neighbor in 2009 has agreed to settle a wrongful death lawsuit that requires the imprisoned killer to pay her more than $5 million. Patricia Price signed a deal Monday to settle the lawsuit she filed against Alyssa Bustamante, who was 15 when she killed Price's daughter, Elizabeth. Prosecutors alleged Bustamante committed the crime to see how it felt to kill someone. Bustamante, who is now 23, confessed to the killing. She was sentenced to life in prison after pleading guilty to second-degree murder. It's unclear if Bustamante has the means to pay the settlement. Attorneys for her and Price did not immediately return phone calls seeking details Tuesday from the Associated Press. Bustamante signed the settlement agreement in March, but documents show Price didn't agree to the deal until the very end, the City News reported. A trial was scheduled to begin on August. Bustamante is serving her sentence at the Women's Eastern Missouri Reception, Diagnostic and Correctional Center in Vandalia. Bustamante pleaded guilty in 2012 to luring Elizabeth to the woods in the small town of St. Martin's, just west of Jefferson City. She slit the girl's throat and strangled her before burying her in a grave she had dug several days in advance, according to investigators. Under the lawsuit settlement, Price agreed to dismiss any remaining counts. Bustamante also is required to notify Price if she receives any compensation arising from publicity about the case. In next disturbing case, we see Christian Hillman guilty of second-degree murder in fatal road rage beating. A jury has found Christian Hillman, 19, guilty of second-degree murder in the September death of 64-year-old William McFarland. The verdict was given after the defense and prosecuting attorneys gave their closing statements to begin Day 3 of the trial in Kent County Circuit Court. Hillman faces up to life in prison. In deciding between second-degree murder and the lesser charge of voluntary manslaughter, the jury was instructed to determine Hillman's intent and whether a reasonable person would determine the killing was justified. In his closing argument, prosecuting attorney Blair Lockman referred to the 7-minute period between Hillman acknowledging McFarland was unconscious during a phone call with his friend, Noah Bolkowski, and when the first police call was made by a witness who reported watching Hillman kick McFarland. "How is 7 minutes not reasonable time to think about what you're doing, to calm down?" Lockman said. "There's no question what took place here. No question about the beating. It's beyond a shadow of a doubt." Defense attorney Michael Bartish repeatedly referred to the incident as a fight. He said the question for the jury wasn't of self-defense but of Hillman's state of mind when he lost control during the assault. "We're not claiming self-defense, but you have to put the scene of what is going on, what the circumstances are, that get us in the situation we're in that caused Christian to act the way he did," Bartish said. Lockman rebuked the notion it was a fight. The incident occurred during the evening, when Hillman was riding a dirt bike along the avenue. A truck, driven by McFarland, approached him from behind, and the two drivers began shouting at each other. They pulled over in the entrance of a nearby church, where the altercation turned physical. By the time witnesses arrived, McFarland was unconscious on the ground, his pants at his ankles. Standing over him was Hillman, who was allegedly kicking him with steel-toe boots. A friend of Hillman's, who had been riding alongside him before the two were separated, caught up, and the two left the scene. Passerby called the police and Hillman was questioned by detectives later that night. During an interview with police, Hillman said McFarland, who he believed to be 35, put his hands on him like he was going to strangle him. Hillman didn't report any injuries to police. "I lost control for a second," Hillman told the detective. "I have anger issues." He also suffered facial fractures, broken ribs, and bruised lungs. Kent County Chief Medical Examiner Stephen estimated that McFarland was kicked 4 times in each side of his rib cage, and at least 2 times in the head. He said he was nearly dead when he arrived at the hospital that evening. Hillman's trial began with jury selection and heard witness testimony before the conclusion. The jury consisted of 10 men and 2 women. This was an absolute shock for the community. The same we can say for the next case. Three young Michigan men who were teens when they were part of a rock-throwing incident that killed a motorist on an interstate were put on probation after spending more than 3 years in custody while their case was stuck in court. The court hearing ended a saga that began in 2017 when Ken White was struck by a rock thrown from an overpass in Genesee County. He was a passenger in a van. "I wish I could take back those regrettable bad decisions," Mark Sikelski said. "I never intended to hurt anyone, and now I have to live with it, knowing I was involved in someone's untimely death." Sikelski, 19, Trevor Gray, 18, and Mikadin Payne, 19, appeared in county court. Their case lasted years because of a dispute over whether they would be treated as juveniles or adults. Judge Joseph Farah refused to honor the request of the prosecutor's office to treat them as juveniles. But the Michigan Court of Appeals in May said Farah had exceeded his authority when he blocked the deal. The three stood in front of a different judge, Duncan Beagle, who asked them, "What were you guys thinking?" "I don't think we were thinking at all. We were just dumb kids," Sikelski said. After completing a year of probation, the three will not have a felony record, defense attorney Frank Manley said. The person accused of actually throwing the rock, Kyle Anger, now 21, pleaded guilty to second-degree murder in 2019 and was sentenced to 39 months in prison. He was released in January with credit for time served in jail before his plea. In this disturbing case, we see the Slender Man stabbing case at the Wisconsin Supreme Court. Geyser, along with then 6th-grade classmate Anissa Weier, was charged with attempted first-degree intentional homicide for nearly stabbing a classmate to death in a wooded area in Waukesha in 2014 over their belief in the fictional internet horror character Slender Man. Both were 12 years old at the time of the crime. Geyser eventually pleaded guilty to that charge and was found not guilty by reason of mental disease or defect. She was committed for 40 years to a state mental hospital. But she and her legal team continue to fight aspects of how her case was handled by a court judge and the appellate court's affirmations. In his petition filed, Attorney Matthew said a review by the Supreme Court is warranted for 2 reasons. One is to clarify the court's precedent governing a juvenile's right to challenge adult court jurisdiction at a preliminary hearing and how mitigating circumstances factor into a ruling. At a preliminary hearing in early 2015, Geyser's criminal defense attorney, Anthony Cotton, argued, "Geyser believed Slender Man would kill her family if she didn't kill someone else, warranting a charge of attempted second-degree intentional homicide. That charge, given Geyser's age, would have forced prosecutors to refile the charges in juvenile court. Judge Michael Boren, however, kept the case in adult court, saying there was other evidence that justified a first-degree intentional homicide charge. Pinnock is also challenging that Geyser's statement to police hours after being arrested was unconstitutionally obtained. Geyser was given her Miranda warnings, which Geyser initialed and signed. In revealing interrogation tapes shown during hearings and on TV specials about the case, Geyser admitted to stabbing Leutner, saying, "It was necessary. I was afraid of what would happen if I didn't," Geyser told Detective Paul Casey of the police department. "I didn't want to find out what would happen if we didn't." During a preliminary hearing, psychologists testified that Geyser was motivated to do the bidding of Slender Man at no cost. What are your thoughts on these court cases? Take a second to write it down. Please subscribe to our channel and check out one of these videos. See you next time around. Take care.